Good morning. Today we are going to see one of the problem questions in adverse possession. We'll start with introduction, then we'll move on to the problem question and how to resolve it, and we'll explore the options. This problem question involves in the adverse position, like there is one existing secret garden, and then we are going to discuss about who possesses that particular garden, whether the party is having a permission to grow the vegetables, to install the sonic devices, and the party is removing the picket fence, and the authorities wrongly enclose the strip. As a disclaimer, this video content has been made available for informational and education purpose only. It is the Darling or Rajeshkumar does not make any representation or warranties with respect to the accuracy, applicability, and fitness or completeness of the video content. Let's move on to the next slide. Have you ever thought about why this law of on the adverse possession exists? Firstly, it is arguably more desirable for the property not to stand empty. Secondly, it is better for the homeless to be housed in the abandoned properties than to be left on the street. Finally, the law seeks to prevent a valuable land from being abandoned and unused by allowing others to take it over if the original owner fails to assert their ownership over an extended period. What is it, the extended period? Let's see in the next slide. Section 15.1 of the Limitation Act 1980 provides after 12 years have passed, a squatter can claim the right to the property. This is because they have treated the land as their own for over 12 years and the legal owner has not objected to it. Let's move on to the problem. Please read through this problem question two or three times so that you can understand the question, as well as you will find a lot of minute things within this question. Charlie brought the registered title to a small cottage in the May 2004. The house used to be the gatekeeper's lodge for a country property, that is, Branwell House. As the cottage did not have its own garden, Charlie agreed with her neighbor Annie to make use of the neglected secret garden at the rear of Branwell House. Annie is the registered proprietor of the Branwell House. Charlie used the secret garden to grow the vegetables. When Charlie license of the secret garden expired in December 2011, Annie was not prepared to renew it because she had plans to replace the garden with a maze. Shortly afterwards, Annie, who was not in the best of the health, boarded up the Branwell house, moved to live in her cottage in Yorkshire. In Annie's absence, Charlie continued to use the secret garden to grow vegetables. To deter the birds, she installed a sonic device to scare them and erected a perspex roof to protect the soft fruit. In March 2021, Annie sold the Brannel house to Emily. A few weeks after she moved in, Emily discovered that Charlie was using the secret garden to grow vegetables. Emily has returned to Charlie, insisting she vacate the garden immediately. A few days later, Charlie received a letter from the legal department of Uthering Council. The letter instructed Charlie to remove the picket fence at the front of her cottage so that Uthering Council can make use of the land inside the fence to build a pavement. It claimed that the previous owner of the cottage must have wrongly enclosed the strip of land with which Uthering Council plan shows rightly belongs to it. So we have to advise Charlie how to handle the situation. So let's to summarize the question. Charlie initially had a license from the Annie to use the secret garden. When the license expired in December 2011, Annie did not renew it and had plans to replace the garden with a maze. Annie boarded up the Brannel house and moved away, while Charlie continued to use the secret garden to grow vegetables. Charlie took measures to maintain and secure and to protect the garden, such as installing a sonic device and erecting a perspex roof. In March 2021, Annie sold the Brownell house to Emily, who discovered Charlie's use of the secret garden and requested her to vacate it. So the key things here is that Charlie continued to use the secret garden after the Annie's refusal to renew the license in December 2011. It can form the basis of adverse possession claim. The key requirement of adverse possession, we know that the factual possession, intention to possess, and the possession that is adverse to the true owner. Charlie continued gardening use of the secret garden even after the license has expired. It likely satisfied the factual possession requirement. The installation of a sonic scarecrow and the perspex roof to protect the soft fruit further demonstrate the Charlie's intention to possess the land and exercise the physical control over it. Annie's plan to replace the secret garden with a maze suggests that a Charlie use of the land was adverse to Annie's intended use. It is satisfying the third requirement. A child can apply to become the registered proprietor of the secret garden as the title is registered and her claim falls within the LRA 2002. The 10-year period of adverse possession likely started in December 2011 when Annie refused to renew the license. The period has now been completed. Let's start with the Schedule 6 of the Land Registration Act 2002. When the Charlie applies, Emily, the new owner of the brand house, will be notified and can object to the application. If Emily objects, a Charlie will need to rely on one of the three conditions in Schedule 6, paragraph 5 of the LRA 2002, to overcome the objection. However, the facts provided does not seem to strongly support Charlie the chances of successes under these conditions. So we are pertaining to the picket fence. We are going to analyze the Charlie enclosure of the strip of the land with the picket fence may also form the basis of an adverse possession claim, as it suggests her intention to possess and exercise the control over the land. The key question is whether the previous owner of the cottage wrongly enclosed the land, as claimed by othering counsel. So we are going to see whether the boundary exception under the LRA2 is going to be applied over here. If the land enclosed by the picket fence was indeed wrongly enclosed by the previous owner, Charlie may be able to rely on the boundary exception in the LRA 2002 to retain the land. The boundary exceptions allows the registered proprietor to claim the land that has been included within the general boundaries of the registered title, even if that land does not strictly belong to the registered proprietor. So let's move on to the satisfying criteria. The key question here is whether Charlie use of the secret garden could potentially lead to the adverse possession, granting her the ownership right over the land. The adverse possession requires satisfying certain criteria, including the factual possession, intention to possess, and a sufficient length of time. Let's see each one by one. In Charlie's case, the Charlie's action of growing vegetable, installing a sonic device to deter the birds, and erecting a perspex roof suggests she was dealing with the land as an occupying owner, would satisfy the taste of the factual possession from the Paul versus McFarlane case. What is factual possession? The factual possession implies some degree of physical control over the land. A trivial or occasional act will not be sufficient, and the circumstances of each case must be considered. In order to satisfy the intention to possess, the second condition, the claimant must show an intention to possess the land, which includes excluding the true owner and the rest of the world from it. The fact that the Charlie made efforts to scare the birds and protect the crop further supports her the intention to control and use of the land exclusively. As well, the Charlie use of the secret garden for growing the vegetable and her continued presence even after the license is being expired, it suggests that an intention to possess. So, the third condition, exclusion of the true owner. A claimant must demonstrate that they are excluding the true owner from the land to the extent reasonably practicable and as allowed by the law. The intention of the paper owner, Annie, are irrelevant in determining the adverse position. The child's continued use of the secret garden, even after the change of ownership, may indicate the exclusion of the true owner. As Emily, the new owner, discovered the child's activities only after she moved in. What is the exclusion of others? Charlie continued to use of the secret garden, including her efforts to scare away the birds and protect the plants, suggests that she was excluding others from the garden as well. However, it is very crucial to assess whether Annie, the registered proprietor of the brand house, had any knowledge or objection to the Charlie use of the garden. If Annie was aware and did not take any legal action to stop the Charlie's portion, it could strengthen the Charlie's claim. So I've just concluded here the both the factual question and the intention to possess in a single slide. Under the limitation period, under Section 15(1) of the Limitation Act 1980, the limitation period for bringing an action to recover the land is 12 years. Charlie has been in the adverse possession of the secret garden since December 2011, when Annie's license expired and Charlie continued to use the grant without the permission. By March 2021, when Emily purchased the Brandel house, a 12-year limitation period has elapsed. The Annie's title would have been extinguished under the Section 17 of the Limitation Act 1990. This is the very key point in determining the possession. Let's analyze our case with the help of the previous case precedents. The Mount Carmel Investment Limited versus the Peter Tharla Limited indicates that the time of adverse possession can be cumulative, even if there are successive adverse possessors. So, in our case, the Charlie's adverse possession can be added to any prior adverse possession of the secret garden by Annie's predecessors, as long as the possession was continuous. When Annie boarded up the Bernal house and moved away, this does not necessarily mean she had discontinued the portion of the secret garden. As per Buckinghamshire County Councillor's Moran case, even if the paper owner has no immediate use of the land, there is no rule that they cannot be disposed by the acts of the trespass that are not inconsistent with their future intended use. Since Annie had a plan to replace the secret garden with a maze, her lack of immediate use does not mean she had discontinued the possession. So the child is factual portion. The child is action of growing vegetable, installing a sonic device, erecting the purpose roof, suggests so she has been in the factual portion of the secret garden. This level of physical control and exclusively use would likely satisfy the requirement of the actual or the factual possession. Charlie's intention to possess. The facts indicates Charlie's use of the secret garden was open and unequivocal, without any evidence that she was merely a persistent trespasser. Her action of cultivating the land and making improvements demonstrate the requisite intention to possess the land and exclude others, as required by the taste in Paul versus McFarland, and it is affirmed in the Pie case. Charlie may have a strong case for the adverse portion of the secret garden, as she appears to have been the factual possession with the necessary intention to possess. Despite the paper owner, Annie continued the ownership. Let's see the Charlie's factual portion with regards to Uttering Council's claim. The Uttering Council is claiming that the previous owner of the Charlie's cottage wrongly enclosed a strip of the land that rightfully belongs to the council. This raises issues of adverse possession. The facts indicates Charlie has maintained a picket fence at the front of her cottage. It suggests that she has been in the factual portion for the of the strip of the land as well. Even with respect to that picket fence, the enclosure of the land with the picket fence demonstrate the Charlie's intention to possess the land and exclude others, in line with the principle established in Powell versus McFarland and Pye case. What the statutory provision says. Under the Section 15 and 17 of the Limitation Act 1980 and the Schedule 6 and 12, Paragraph 18 of Land Registration Act 2002 are relevant statutory provisions governing the adverse possession claims. If Charlie has been the adverse possession of the slip of the land for the requisite time period, she may be able to establish the ownership through these statutory mechanisms. The removal of picket fence. A claim by Wuthering Council that the land enclosed by the picket fence in front of the Charlie cottage belonged to them is more questionable. The key case here is Buckinghamshire County Council versus Moran, which establishes that mere facts of enclosure does not necessarily give rise to adverse possession. A Charlie would need to demonstrate that her portion of the land inside the picket fence was also open, continuous, and with the intention of the possess it as her own. The council claim seems to be based on assumptions that a previous owner wrongly enclosed a strip of the land, which may not be sufficient evidence of the adverse possession by Charlie. Further supporting our case, in the Lambeth London Borough Council versus Arganel, the court found that by padlocking a front door is a clear demonstration of possession. A Charlie action of installing the sonic device and the perspex roof could be seen as a similar act demonstrating her possession of the sacred garden. In Battersea Freehold and Leasehold Co-Limited versus Wandsworth London Borough Council, in this case, however, in Battersea, the allowing the access for others was held to show a lack of intention to hold the exclusive position. A Charlie use of the garden was with the Annie's knowledge, which may suggest a lack of intention to possess it adversely. In Simpson versus Ferger case, the court clarified that the act of exclusion of the paper owner are required, and a mere declaration of the intention is not enough. A Charlie action may not be sufficient to demonstrate the required level of action, required level of exclusion. What about the land in front of the cottage? The Uttering Council has claimed that a previous owner of the cottage must have wrongly enclosed a strip of land in front of the cottage, which rightfully belongs to the council. The key question is whether the Charlie has acquired title of the land in front of the cottage through the adverse possession. In Thorpe vs. Frank case, the court found this permanently repaving and altering the level of the small triangular piece of land amounted to adverse possession, even without enclosing the land. So, however, in Amit Raja versus White case, the court found that gating and enclosing a passageway was insufficient and too equivocal to demonstrate the intention to possess the land. So, based on these precedents, the Charlie action of enclosing the land with a picket fence may be sufficient to demonstrate the factual portion. However, the council's claim that a land rightfully belongs to it would suggest a lack of Charlie's intention to possess the land adversely. What happened to the interpretation of the limitation period? In the case of Buckingham Country Council versus Moron and Boozy versus Davis case, it suggests that the limitation period can be interrupted if the paper owner Annie regain the portion of the land, or if the child is use of the land is within the permission of the paper owner. However, the facts indicate that Annie has not actively reasserted her ownership or regained the possession of the garden since moving after the Banner house. Additionally, there is no evidence that Charlie continued to use the garden was with Annie's permission. The privy council decision in Smith versus in the Smith case suggests that a license may be implied if the adverse party use it compatible with the owner's intended future use. However, the facts does not indicate that Charlie's use of the garden was compatible with the Annie's plan to replace it with a maze. What is the effect of the lapse of the time? As per the principle established in Asker versus Whitelock, the expiration of the limitation period does not automatically transfer the paper's owner's title of the adverse possession. Rather, it extinguishes the paper's owner's claim and the adverse possessors gain a legal estate in their own right. The adverse possessor, in this case, a Charlie, would be bound by a pre-existing burden on the land, such as restrictive covenants, even if they were not duly protected under the Land Charges Act 1972. A Charlie would be able to create a new right of for the land, such as easement, sell the land, or apply for the first registration of the title under the Land Registration Act 2002. The claim of uttering council's claim about the wrongly enclosure, the principle established in the Hanslow versus Minchton and Yam versus Chowdhury case suggests that the council claim would need to be assessed based on the specific facts and evidence regarding the ownership and boundaries of the land in question. Coming back to the boundary exception, it applies where the exact boundary lines is not determined and the applicant has held adverse possession for at least 10 years, reasonably believing the land belonged to them. The exception only applies to the true boundary disputes where the disputed land is adjacent to the squatter's land. The reasonable belief requirement is based on the claimant's own knowledge and not that for their agent. The reasonable belief need not continue right up to the application as long as it existed until a short time before. The reduction of adverse possession period to 10 years of the registered land, the inability to tag periods of possession by the successive squatters, except where one is the successors of the other. The potential impact on the doctrine of acknowledgement as possession can no longer extinguish the registered title under the 2002 Act. Let's discuss the critical questions. If C is continuing gardening using the allowed under the license enough or too trivial to satisfy the requirement of adverse possession, Charlie use a secret garden for growing vegetable can be seen as open and notorious as she installed a sonic device and erected as purpose roof to protect the crops. Thus, installing the sonic scarecrow and the roof to protect the fruit. Sees claims to possess land with intention and sufficient physical control. These actions demonstrate her active involvement in maintaining and improving the garden and suggesting a level of possessory intent and the control. How does Charlie's protectionist motivation for this action? As A is planning to replace the secret garden with the maze, affects the Charlie's claim to being in adverse possession. Charlie protectionist motivation may indicate a genuine possessory intent, while Annie's plan to replace the garden may suggest that she did not consider Charlie's use of the land as a significant infringement. We all might have thought the key question of when did the 10-year period of adverse possession start? The passage does not provide information about the exact start date of Charlie's adverse possession claim. However, based on the information given, it can be inferred that the Charlie's claim could only have started after Annie refused to renew the license in December 2011. This is a very critical question. Once the 10-year period of adverse possession is completed, Charlie can apply to become the registered proprietor. Emily will be notified, and if she objects, it may effectively be the end of the matter, unless a Charlie can mobilize one of the three conditions in Schedule 6, paragraph 5. If Emily objects to Charlie's claim, it may bring the matter to a halt unless a Charlie can rely on one of the three conditions specified. Yes, once Charlie fulfilled the 10-year period, she can apply to the registered proprietor of the land, and the new owner will be notified about it, and it's a very critical issue. The council letter allows the advice to be given both about the elements of the adverse possession claim to the land enclosed with picket fence, and also on the whether the C can rely on the LRA 2002 so-called boundary exceptions. Yes, the boundary exception allows the claimant to possess the land enclosed within the registered boundaries, even if it is not technically part of their registered title. It suggests that advice can be provided on whether the Charlies can rely on this exception in her situation. Let's conclude overall. It is likely that Charlie has established a valid claim to the secret garden through adverse possession. A 12-year limitation period has lapsed, and the Annie's title has been extinguished. Emily, as a new owner of the Branwell house, would not be able to successfully evict Charlie from the secret garden. Charlie has a strong case for establishing the adverse portion of the secret garden at the rear of the Branwell house, as she has been in the factual portion of the land for the potential period exceeding the 12-year requirement. And there is no indication that her use of the garden was with Annie's permission or that Annie has actively reasserted her ownership. So, in summary, Charlie has a strong case of an adverse possession claim to the secret garden, as she has been using it continuously since the expiration of the license in 2011. However, she may face challenges if Emily objects to her application to become the registered proprietor. Regarding the land enclosed by picket fence, Charlie may be able to rely on the boundary exceptions in LRA 2002 if the council claim that the land belongs to them is not well founded. That's it. Thank you.